Hi everyone, I'm Anthony and this is the Property Show, and today I'm going to be talking about cautions, charges and usufruct. What are they and what can they do for you? Well, if you're a high net worth individual or if you're living in a valuable home sitting on a lot of assets, there comes a time when you do have to take into account death taxes. There was talk about extending the period to 15 years. At the moment it's still 7, meaning that if you give something away within 7 years of you passing away, then death tax can be applicable, albeit on a sliding scale. Governments were toying with the idea of extending that to 15 years, so basically you would have to live for 15 years after giving away your assets for them to be considered a gift and not come under the net of death tax, provided you obviously are in excess of the threshold. So you live in a very expensive home or whatever the case may be. How can you transfer assets away to your children, loved ones, whatever the case may be, but not put yourself at risk? If you were to give your home to your children, they're your little darlings, bless them, but there's no guarantee that they won't throw you out or mortgage the place or whatever the case may be. Now, this is where we can look at cautions, we can look at charges, and something that maybe many of you may not have heard of called usufruct or a usufructuary charge. That's something different. So first of all, some people protect their assets with a caution. This is often done by divorce solicitors, say when one partner leaves the matrimonial home and their solicitor on their behalf, because the house will remain for the other partner, perhaps with the children, will place a caution on the property to protect the other partner, the departing partner's interest in that property, so that when the children grow up and it's sold, the departing partner can get their share. In reality, what actually happens, the departing partner leaves with nothing, starts again, buys another property, accrues some equity, and then the remaining partner simply applies to the court on the grounds that the other partner is self-sufficient to remove the caution, and more often than not, the court just agrees to remove it. That can apply with a property. If you were to say hand it over to your children, you could place a caution on it so they couldn't mortgage it, etc. But it's not really guaranteed. You are at the mercy of a judge, and it doesn't guarantee you the right to remain within the property. The next step you can cover yourself in terms of equity is with a charge. However, if you are looking at planning for death tax, then a charge is no good, because a charge on another property, yours or anyone else's, is actually an asset. So if you have a charge of £500,000 on a property that does not belong to you for whatever reason, in your estate, that charge will be tallied up as an asset of £500,000, and your benefactors will have to pay tax on that. So that doesn't help either. Then we come to the usufruct or usufructuary order, or whatever you want to call it. This is not really very well known, but it's actually one of the oldest laws of all. It goes back to Roman times, and it was actually a law where you could give somebody, originated with land, you could give somebody usufructuary or use or bearing of the fruits of land as if it were their own, provided that they do not cause any damage to it, for as long as the order allows, or normally in most cases for as long as they live, but they never own the land. So this can apply to property. It's often used in divorce hearings, especially through Europe, where the courts often make orders to give assets to the children. I've actually had experience of it myself, so that's how I know how it works firsthand. And take it from me, it is watertight. So basically, you want to transfer an asset to your children. Perhaps you were looking at equity release, where really your equity that you've worked hard for is literally you're getting 30% of it or 40% of it, and the company's literally going to just accrue interest, and they're going to take almost the whole property after you've gone, when you're not around to contest it. All the small print will come out and they'll have the lot. Whereas if your children are comfortable, you might agree with them that if they give you a monthly amount or a lump sum or whatever the case may be, you could transfer your property to them in plenty of time to avoid death tax, but you actually write into the deed, and you and your spouse, if applicable, will then have a usufructuary order on that property to use it as your own home for as long as you live. And nobody can remove you from that property. It cannot be mortgaged, it cannot be taken, the order cannot be overturned in the court, provided it was done legally in the first place, of course. And that guarantees that you have your home for the rest of your life, and provided, at this point anyway, now, you live beyond 7 years, your children will actually gain their inheritance tax-free, and there'll be no complications, and that will protect you. Obviously, don't take my word for it. Take my word as a starting point. Research it, but I can tell you for a fact that this order can protect you if you wish to transfer your assets to a partner, children, but still want use of the property and don't want to worry in case anything goes wrong. It's not always a case of your children possibly being underhand. Maybe you transfer your property to your children and they get divorced and their spouse's solicitor forces a sale. When you have a usufruct or a usufructuary order on that property, then for all intents and purposes, for as long as you live, nothing will happen to that property and nothing will interrupt your right to enjoy that home as your own for as long as you live. What they do beyond that is between them, their spouse, and the divorce courts. That's all I can say. So look into it, and that's all for today. Thank you very much. Goodbye. See you on the next show.